versus Deontay Connors, case number 23FB 1053. It's a recall.
Rachel McDuffie for the people.
And good morning, Your Honor. May it please this honorable court, Matthew Rosenthal on behalf of Deontay Connors. Deontay Connors, can you state your name for the record, sir?
Deontay Connors.
Thank you very much.
Thank you, Your Honor. We did look over the PSI report, so thank you for giving us time to do so.
You're welcome. Any corrections, deletions, additions to be made to it?
I think everything is correct, Your Honor. The only thing we are worried about is my client does use medicinal marijuana for his spinal issue that he has. Discs in his lower back are contorted, so therefore he gets a lot of pain. He used medicinal marijuana and has a card. From my understanding, it had to be validated through probation or from you, Your Honor. But other than that, that would be the only thing that we would ask the court in question if that would be an issue.
Thank you. He does need to get permission from the court to use any medical marijuana.
Absolutely, Your Honor.
Ms. McDuffie, anything from the people?
Thank you, Your Honor. So I, for the most part, I do agree with the recommendation. And I can appreciate that Mr. Connors doesn't really have, any significant history. My concern is always with insight. And so I can see here, one of the things that kind of stands out to me in any case where somebody says essentially, he was upset, and according to the statement in the PSI that, had that other car not swerved, he wouldn't be in this situation because he wouldn't have ended up in a situation where he was patted down and then the weapon was found. Or when somebody in a drunk driving case says, I was almost home. That's a signal that basically says to me that, I almost didn't have to get caught and deal with this at all, which doesn't really speak to the underlying issue. And here, sure, people may not be advised about the weapon, but it's really not so much about that. There was an underlying sort of anger issue, as far as I can see, which is the way that he responded when he was approached by the police in this matter. That just to advise you, or just to advise Mr. Connors, rather, of a simple sort of traffic thing that may have just been a brief conversation and a warning and let go about a seatbelt, seemed to escalate unnecessarily. So with all that said, I hope that Mr. Connors understands that if he's not here because a car pulled in front of him, or he's not here because of the seatbelt, he's here because of his behavior that led up to this point. And I hope that, I don't know if anger management is not something that was in the recommendation, and if the court finds it appropriate, I think it might be good for that to be something that he looks into, because it seems to me that that's where all of this really originates from. It's just a little bit of impulse control problems and kind of an outburst there. If that's not something that's necessary, I'm fine with that too, but it's just something that stood out to me. That's all from people.
Thank
Absolutely.
you.
And if I may, Your Honor, just to talk about Deontay a little bit, I just wanted to ask that briefly, but no, he understands that day, he was dropping his daughter off. His 2-year-old, he was feeling sick at the time. A car kind of hit the brakes. He swerved. He was pulled over and didn't take it well. And he knows that. And, he knows that in those situations, if he would have acted more appropriate, more cordial to the police officers, it would have just been a seatbelt infraction and he would have been on his way. He didn't know about the brass knuckles being an illegal weapon, Your Honor. However, ignorance isn't a reason for this not to be charged. And he understands that as well. He had the brass knuckles because he didn't have a concealed pistol license. He didn't want to deal with a gun, and he had those. He did get them off of Amazon, and now he knows he will never, have brass knuckles, but as well have better communication with any authority figure when it comes to police, when it comes to government officials. He is taking a weapons safety course that is part of the plea. If anger management, is something that we need to look over, I think we can. He just really wants to get this behind him. He does live with his spouse, with the 2 children. He's about to get a promotion, Your Honor, works for U of M. And his promotion's a 6-month placement where he'll be a manager, a manager working as a manager, and hopes to become a manager where he's working now, where he's been working for the last 6 years. He doesn't have any other criminal history. And this was an instance where he does understand that he needs to be more corrective with how with his mannerisms and how he approaches government officials and police officers. But he really wants to put this behind him, Your Honor.
Thank you. Mr. Connors, anything you want to say, sir?
I just wanted to say that the way that the incident happened, I wasn't saying it as if I wasn't saying it in the way that she was trying to make it sound. It was just simple as if you see a situation like that, why wasn't both vehicles pulled over? I felt like there was no reason why 4 officers should have pulled one car over. That's what I was saying. But like I said, but like the lawyer said, I do understand that I should have came with a better attitude. But I had a lot going on. I had just worked a 16-hour shift the day before, and then I had to drop my daughter off early the next morning. I was literally going home to go sleep and trying to feel better, and then all of this led up to that. It was no excuse. It was nothing. It was just simply I had a lot going on, and it piled up, and it came out at the wrong time. And I apologize for that. And I'm just trying to move forward so that way I can continue making the good paths that I've been paving for myself.
Absolutely.
Anything else, sir?
No, that's it.
I did review the police report. I had some similar concerns to the prosecutor and was waiting to hear what you and your attorney had to say. Your demeanor today is concerning to me as well, sir.
Meaning what?
Meaning what I just said, that your demeanor is concerning to me. I think you do have issues with authority figure, because the first thing you did was, once the prosecutor said something, instead of you allocating your regrets, you wanted to actually attack what she had said.
I wasn't attacking what she said. I was defending myself for what she said.
There you go. My point exactly.
I was defending myself.
And now you're giving me back talk.
And he is sorry, Your Honor.
I
This
don't
was
think
just
he
a
is,
very
though.
hard incident.
I really don't think he is.
I promise you I am. I promise. I'm working hard. I mean, I'm going to school. I'm trying to stay on the good path. Like, it was one bad incident.
I agree with all that. I believe all that. It's your attitude, though. That's the problem. And instead of not giving it today, you couldn't resist it. You did it again today. And I was hoping you didn't.
I didn't have an attitude. I don't know if I don't know. I don't have an attitude. I promise.
Anything else you want to say before I sentence you today, sir?
Your Honor, I promise I don't have an attitude. I don't have an issue with authorities. It's just that day it was a really bad day. That's it. I deeply apologize. I'm trying to make the right choices to better my life. That's it. I really am. I truly am sorry. It won't happen again. You won't have any issues with me. I promise. I'm doing everything I can to make the best decisions for me and my kids. That's it.
I understand. I think the problem is that you don't know how to do that, because the best decision today would have been just to be apologetic.
And I am. I apologize. I promise you. I'm sorry for my actions for that day.
Anything else?
I'm not making any excuses. I'm not. I promise. I know that I made a mistake.
There's a sentence of this court, sir, that you're on probation for 6 months. 363 days, 65 days in the Washtenaw County Jail. 2 days credit, 363 days are suspended. You do everything you're supposed to do. then you won't have to do any additional jail time, sir. $725 of fines and costs, $30 per month in probation oversight fee. You must meet with probation when and where directed, including any and all home visits, make earnest efforts to maintain legitimate employment, complete the weapons safety program. There's no assaultive or threatening behavior towards anyone else. You're to submit to, pay, and be responsible for random drug and alcohol tests as requested by the court, probation, or any probation officer. No use or possession of alcohol, marijuana, medical, recreational, illegal, or otherwise, unless approved by this court. No being in the presence of anyone having those. No use or possession of any firearm components, ammunition, dangerous weapon, or being in the presence of anyone using those. You must complete an anger management class. And it must be at least, is there a 30-day, Ms. Johnson?
For the impulse control class,
Yes,
there's a 1-day, 4-hour program through Crossroads recovery.
I'll just do that one. And you also will be under the prosecutor's deferred sentence. I'm going to do a 60-day review to see where he is. October 19th, 2023 at 10 a.m. Sir, you need to contact the probation department after 9 o'clock tomorrow to go over your probation requirements. Do you have the phone number?
I personally, I think I do in the email.
Please call them tomorrow after 9 a.m., okay?
And then, Your Honor, if I may, and I'm sorry, I did not add, and I just wanted that his car was impounded outside of the 2 days that were credited for $450, and he did pay for that. I'm not saying that go to fines and costs, but I did want to put that on the record as well, that he was up to date and paid for that forfeiture as well, Your Honor. And then with the medicinal marijuana, would that be something that's going through probation to validate for use,
Yes.
Your Honor?
It's submitted to the probation department, and then what will happen is they'll submit it to me. I'll review it. I'm looking for the necessity of it so that you know. That's the piece that I look for. Upon submission of it, if I find that there is a medical necessity, I generally approve it.
Thank you so much, Your Honor. And thank you, Prosecutor McDuffie. I appreciate you.
Take care.
And thank you, probation officer. Thank you so much. And that we'll be reaching out to you, and then I'm going to give you a call, Mr. Connors. Thank you, Your Honor, and thank your court staff.
Thank you. Have a good day. To have a hearing in this matter and admit to the violation, and that you, as soon as I sentence you, make contact with the victim in this particular case.
Yes.
All right. So, sir, you sent the victim a text, no, I'm sorry, a Facebook message as soon as you were sentenced in spite of my order to have no contact?
I actually received an Instagram message from her first. I blocked her on Facebook and I got her phone numbers blocked. And I got a text message from her second Instagram account. And I just replied saying, congratulations. Like, you see exactly what I said. I just said, congratulations, like, got what you wanted. I didn't know that, like, I knew I couldn't initiate contact, but I thought replying, like, I mean, you know, I thought if I replied, I wouldn't be in violation. I had no idea. If I would have known that, I would have never replied and I wouldn't have gotten this violation.
All right, I find that there's a knowing and willing admission to the violation of the probation. Are you satisfied, Ms. McDuffie?
With the factual admission that it happened only, yes, Your Honor.
Satisfied, Judge. Thank you. Miss Akiri, do you have anything to support the fact that a message came to him first? Because the documentation that I have only shows his him getting her.
Correct, Your Honor. And that's what I informed Mr. Forbes when we first spoke about this while he was in custody. He stated that if he had known, he would have taken his own screenshots. We do not have any screenshots of his side of the messages that were received from him. It just shows the very first message as shown. So no, Judge, we don't have anything to corroborate that. It obviously has been difficult because he's in custody and he doesn't have access to any of his information. And he didn't know about these charges until after the fact, after he was placed in custody or he went into custody.
Ms. McDuffie, anything you want to say in this matter?
Most definitely, Your Honor. So first and foremost, Mr. Forbes, I believe, was under a no contact order. Probably he was under a no contact order or should have been with Ms. Tajane Roberts from his other case, if nothing else. I understand that the case in this one was related somewhat to that, but it was dealing with her father. However, he should have already been under no contact orders with her. Secondly, after he spent the sentencing itself walking around, not really paying a lot of attention to what was being said, but there shouldn't be any confusion whatsoever with what he was ordered to do, because regardless of whether she reached out to him first, which I don't have any reason to believe that she did, he knew he was not supposed to talk to her. Nobody ever specified only initiating contact. And the content of what he said was to immediately victim blame her for him being in this case, in this situation. And as we discussed at the sentencing, he's here for his own actions and refused to take any responsibility for it, even at the time. So to go to that victim with probably not even 15 minutes passing to say, congrats, you got what you wanted, and to suggest that she's somehow jealous of him being with somebody else, just reaffirms everything that we have been concerned about from the very beginning. So it really doesn't matter whether she reached out to him first or not. He knew better than to do what he did. So that's my biggest issue, is that there's still no insight, no acceptance of responsibility for his actions whatsoever. And to stand here today and say that had he known, he wouldn't have done so holds absolutely no weight of water with the people.
It's documented though that she went to take off that no contact with the last case. She went up there herself. And a month prior before sentencing, I have text messages of her clearly stating that she wanted to get back with me, and I was clearly telling her I don't want to. She paid for a hotel a month before sentencing for us and everything. Like, I have all of that proof. And I kept telling her I don't want to be with her no more.
So you're just now admitting to violating the no contact provisions of your bond, because you had a no contact provision in this case then as well.
The no contact in the last case, she went up there and got
In this
the
case,
contact
I
order.
don't care about the last case. I can't tell you what another judge is doing. I can tell you that you were ordered by this court starting on January 25th to have no contact with her.
Yeah, and I take full responsibility for replying to a text message, yes.
No, you just said here today that in the last 90 days, which was after January 25th, you were in a hotel with her.
Oh, I said she wanted to get.
Well, how would she know? How would he know?
She texted me. She kept calling me off of blocked numbers, text-free numbers. I have no reason to contact her. I don't want to be with her, and she knows this. I've been telling her since then.
Ms. Ikiriakin, anything else you want to say on behalf of your client?
Your Honor, what we're going to be asking for in regards to sentencing, Mr. Forbes, I think that if this situation has taught him anything, it's that this court is not inclined to accept excuses or games when it comes to this particular situation. Mr. Forbes very much so understands the orders that have been placed on him. He is hopeful that the court will consider a release based on the original sentence. I'm hoping maybe we could do increased classes, something to that effect, Your Honor. That our request today is just in regards to the sentencing, that the court consider not remanding him and still giving him an opportunity to complete probation. I know that this is extremely problematic because he was on probation with the other case. It should be noted that that other case he was found guilty at trial. However, they were able to move forward with the trial without cooperation from the complaining witness in that case. From Mr. Forbes, my understanding is that she was present at the trial, supporting him the whole way, but there was still able to be some type of conviction for the charges based on the evidence that had been presented. I say that to say, Your Honor, that it's a very unideal relationship. I don't want to go as far as to call it toxic because I don't know the details and the intimate details with that.
I don't know how else you could define toxic if this isn't toxic.
It's definitely a relationship that doesn't serve either party. Mr. Forbes he's ready to move forward with probation. He's asking that the court give him an opportunity to do probation, to do whatever classes may help him deal with whatever issues he's dealing with that has him repeating these behaviors that finds him in front of the court, especially when it comes to this particular complaining witness. I know it's difficult because Mr. Forbes says that he's taking full responsibility, but at the same time, he's making some type of admission that removes some culpability or responsibility from himself. I don't think that he has fully grasped how his actions are affecting his outcomes. And I think that some classes that could be offered from probation could allow him to see that and help him with accountabilities. They're both young. He's young. I don't have his age in front of me, but that is his primary concern today, Judge. I instructed him. He understands that this isn't a situation that we can take to hold a hearing for, and that he has messed up once again, and he is pleading guilty and ready to take responsibility for that. And we're just asking in that responsibility that the court still give him an opportunity to do probation.
Your Honor, I'm so sorry, but I have a request, so I just need to be able to answer this accurately on behalf of the court. I understand, obviously, this is not sentencing, so we are not in a position to have any sort of victim impact statement. However, as you know, Mr. Calvin Flake, who spoke quite powerfully at the sentencing, is basically asking here behind the scenes that even though there was an admission, there's allegations being made that are sort of evidentiary types of issues. And so if the things that are being raised with the claims of what his daughter did are coming into question with respect to how the court is going to act, he just needs to confirm whether or not he is able to provide any other documentation or speak or address this issue. Since those things, there's an admission with basically allegations built in. So I just need to be able to tell him, no, he is or is not going to be able to speak to the court about this in any way.
We're going forward with sentencing. I can figure out what's going on here without any additional information.
Your Honor.
Yes.
I believe the father of the victim made a statement that if we can go into a breakout room, I can go into more detail about that.
Violation there. The main thing that I have heard is another opportunity for your client, Ms. Ikiri Akinruli, to accept responsibility and not accept responsibility at the same time. I was very clear to have no contact. And his contact was not only immediate, reactionary to my sentence, but also a re-victimization. Regardless of what anyone else has to say about that, that is my major problem. Whether she contacted him or he contacted her first. The fact of the matter is that in retaliation for what I did, he made comments that were intended to re-victimize despite everything I just said to him within less than 15 minutes. It's a direct and blatant disregard of my order. And if he wasn't already on probation, would be contemptible. I agree with you that your client needs classes. He's going to start those classes in jail. Is he in MRT or anything like that while he's in custody right now?
I'm in MRT.
How long have you been in that?
I got in, I think, I want to say like a week or like a week and a half when I came in. And I'm like, I've done 10 sessions already. And we can do, it's like Monday and Friday. And I'm on like my 10th session right now. Tomorrow would be my 11th session.
I'm wondering if you're learning anything.
I'm learning a lot. It's definitely like opened my eyes to like a lot of like childhood stuff too. It's like probably caused me to like act and think a certain way and handle certain situations. It's definitely opened me up. I say that a lot.
So, this charge here is a 100, is it a 180 or a 90-day max? Let me see where we are.
Really 180, Your Honor.
And I initially gave you what, upfront 90 days?
Yes.
That was on July 6th. So you're going to serve an additional 15 days at this point for the violation. I believe that the MRT program is a 6-month program in the jail. If you violate again, if you have any contact in any way, shape, or form, through you, through a third party, through anyone else, you're going to be looking at just doing the time. Do you understand that part?
Yes, ma'am. Trust me, I won't have any type of contact, reply, or nothing.
All right.
I have one question. So you said, so my out date was the 19th of next month, so it would be that plus 15 days?
That is correct.
Okay. And then I just gotta complete MRT when I get out?
There is there was a long list of things you need to do when you get out, sir. You're
Okay.
going to contact the probation department when you're done, and they'll go over that list of things with you so that you are clear on what needs to be done. Okay. You'll finish the MRT when you're out if you don't do anything else while you're in there. Okay.
And I'll just go to community corrections right up here?
Correct. Exactly. All right. Thank
All
you.
right.